with Professor Nina Pillard, a law professor at Georgetown University Law Center, and we're here talking about AT&T Mobility v. Concepcion, which is a case that the Supreme Court will hear very soon. Professor Pillard, could you let us know what exactly is this case about, and why is it before the Supreme Court?
Well, Jeremy, this case is it's an interesting question why it's in the Supreme Court, because it's a case that deals with state law contract issue. And I would characterize it as sort of a class action ban case in arbitration clothing. So the federal hook that gets it into the Supreme Court is the contention by AT&T Mobility that California, which uses its state contract law of unconscionability to invalidate contracts that require consumers and others to give up their rights to proceed as on a class action basis. California uses contract law in that way, and the claim by AT&T Mobility is that because the class action ban in this case was in an arbitration clause, invalidating the class action waiver in that way violates the Federal Arbitration Act. So, as we know from the recent series of cases in the court, the Federal Arbitration Act prohibits courts from disfavoring arbitration. Right? The idea is that this law says if parties want to agree to arbitration, that's fine, and a court should not feel that its power is somehow being privatized or taken away by the existence of an arbitration clause. And the Supreme Court, has been pretty robust in enforcing arbitration clauses, and we've seen a rise of this private form of dispute resolution. And in light of that, in light of the court's relative enthusiasm for arbitration, the lawyers in this case have sort of inserted the class action question into an arbitration clause, and in that way really hoped that the class action ban can ride on the arbitration clause coattails. Now, one of the things that you see is an effort here, I think, to do in a kind of private way through contract a version of tort reform that the defense bar has been unable to do through legislation, right? We know that a lot of American businesses are not fans of class action. It's a very strong deterrent against unlawful conduct. It raises the risk that unlawful conduct will, in fact, be remedied, and that there will be broad cases brought. And understandably, American businesses would rather that there were no such thing as class action law. So by writing a class action ban into a contract, they're trying to get rid of it. Now, the state courts, under state contract law, in many instances say, no, you can't exculpate yourself that way. Class actions serve a purpose, and under our contract law, it's unconscionable to put that kind of ban into the contract. That's just a state law question. The Supreme Court has no access to that. So to the extent that a state Supreme Court, like California's Supreme Court, says, our unconscionability law disallows this, at least in some cases, where it acts in an exculpatory way, the Supreme Court has no access to review those kinds of cases. What's happened here is because the class action ban is in an arbitration clause, the argument has become available to AT&T Mobility to say that invalidating that is invalidating a chosen form of arbitration and violates the Federal Arbitration Act.
Okay. I'll let you go in 1 second. If AT&T, if they're able to convince the Supreme Court of their argument, what is the potential impact? I guess it largely depends on the narrowness or broadness of the ruling?
It does. Now, I think it's going to be a steep climb for AT&T Mobility to persuade the court to reverse. However, the court has taken the case, and if they do reverse and hold that California's law is preempted here, I think they're most likely to do that narrowly. But what we see is the signal that that kind of decision would send, and the very case-by-case battles that that's going to create. in a circumstance in which plaintiffs can show that the class procedure is really necessary for them to vindicate their rights, then under a negative Supreme Court ruling, they might still be able to go forward, but it's going to raise the hurdle of actually having to make that case, and it's going to put a presumption against class action proceedings, even under a narrow ruling in favor of the petitioners in this case. So it's a potentially a very significant case.
Okay. Professor Pillard, thank you so much for taking the time to talk to us.
Thank you, Jeremy.